Thank you, David.
Well, you're very welcome. And Justice Kennedy, this has been a long tour for your book. You've been at it for weeks now, haven't you?
Well, being in California is never too long. It's never long enough.
Well, let's start at the very beginning. The very first sentence of your book is, quote, "To understand ourselves, we should understand the time and place of our birth and origins." Now, currently, here at the Ronald Reagan Presidential Library and Museum, we have a new exhibition on cowboys, history, and Hollywood, and it explores the culture of the West. And you were born in the West, and you write that the West infused itself into just about every memory of mine, every story, and every lesson, and the West helped bring me back down to earth when I felt too self-important. So what is it about the West and growing up in Sacramento that continues to shape you to this day?
Well, the West drew people for hundreds of years, from the East Coast, first to the Midwest, then further and further. As Steinbeck said, we're always east of Eden. We're never quite there. And so this was an allure for so many. What did the West mean? Well, it meant that you were free to make friends, to be in open space, both in a literal and figurative way. There was always something out there for you to find. When you went to California, did that end? Did you have to go to Honolulu next? Not really, because California is so rich, so beautiful, so wonderful in its physical resources and in its people and its hope and its history, that there's always something beyond for you to look for. David, does it sound patronizing if you're an Easterner to say, well, what is this stuff about the West? Well, the Easterners look backwards to begin with. They look at all they did for the founding of this great nation, and they look at what, both in pre-colonial times and in colonial times, they accomplished to make America great. And from looking back, they see the greatness, and then they look forward to see how they can continue it.
Well,
they look backwards first and then forward.
Right, and you've now spent decades in Virginia, so you have some East Coast credibility and chops, don't you?
Oh, well, Ronald Reagan, when he asked me to take the position on the Supreme Court, I said, well, I don't know anybody back. He said, oh, you know me. And,
well, let's get into that, because you were reluctant to take the role. And how did he convince you to do something that you weren't that willing to do? By the way, something that many jurists would have done anything to do.
Well, when he was governor, occasionally I had good access to him because I never was going to ask him any favors, and he always was very good about listening to my comments and to my advice, but sometimes he'd say, now the rule is, I said, no, Governor, I tell you the rule, do whatever you want, but let me tell you the rule. So when we were having this discussion about our moving to Washington, D.C., he said, oh, the rule is, if I ask you, you have to come. And I said, are you going to tell me the rule again? But he was right. If you're asked to do this for the judiciary and for the law, you have to come. Mary still was teaching and had not long, maybe 18 months, 2 years to get her full retirement, and so this thing is falling out. Tell me if my remarks are hitting the floor. So we originally we thought, well, maybe I'll commute for 18 months, but then Mary wouldn't have had the adventure of discovering Washington. So we came back together, and Washington was very receptive, very, very kind, very, very wonderful place.
We'll dive in, of course, to your years on the court in a moment, but when you got to know then Governor Reagan in the 60s, you actually, you set some boundaries on what you were willing to share with him. There were two things that you told him, don't ask me about these things.
Well, when he became governor, there were certain things, as a lawyer, he asked for my help on the lease of his house and so forth. And I said, Governor, there's two things you should never ask me. He said, oh, what are they? And I said, well, the first is you should never ask me who should be a judge. And he said, oh, that's where you can maybe really help. I said, maybe so, maybe no. But if you get that reputation, you're a lawyer, David, for being a judge maker or a judge breaker, that judge is either going to lean over backwards in your favor or back the other way to show that he's not giving you a favor. And I just didn't want that. And he said, what's the second thing? I said, don't ever ask me about politics. As an informed citizen, it was important for me to know what the issues were. But insofar as campaign strategies and stuff, A, I didn't know anything about it. B, he had one of the best political teams ever assembled in Sacramento, Deaver and Meese. Down here, the kitchen cabinet, wonderful, brilliant people. They didn't need my help. So those were the two things I told him never to ask me about. And he told Nancy about that. She insisted, she told me to please come by the office at any time. It seemed to be necessary to do so. Nancy, I saw her pictures here, of course. One time was asked to christen the aircraft carrier named for Ronald Reagan, the USS Ronald Reagan. And they asked me to come down to speak, and so we flew down there together. And the president was, then the former president was in California, but couldn't really come. And she looked up at this huge carrier, 5 stories high or something like 4,000 people. She said, it's too bad Ronnie isn't here to see this cute little anniversary present. And I had told her, I said, you've got this scheduled for February, or I think it was February. I said, the weather's bad down there. It's Norfolk, Virginia. Why don't you wait until the weather's better? She said, no, it has to be this date. It was because it was their anniversary. Mm. Nancy was big on things like that.
Yeah. Well, so it's 1988. The Senate confirms you. You become an associate justice. What was your first day on the court like?
Well, it was fascinating to be on the Supreme Court. You sit according to seniority, i.e., how long you've been there, and the junior justice sits on the far left. The next most junior, the far right. So then you work your way up toward the middle. So I was on the far left, looking down, and I wondered what. Should I start the questioning or should I participate in it? But I didn't have to wait too long before an attorney said something that I thought needed a question, so I asked the question, and my colleagues thought it was an interesting question because they pursued it, so that was my beginning point.
And as you reflect on your many years, both as an appellate judge and as a Supreme Court justice, but also an attorney in private practice, what makes for a good judge?
Well, one of the things is that the judge must always ask himself, why am I doing this? Is there some bias, some hidden motive? And that's the fascinating part about this judge. In Shakespeare's Hamlet, the first question is, who goes there? And Hamlet asks himself, David, all through the book, who am I? all of us have to ask ourselves this in every profession and in life. You can't ask yourself every minute, why am I doing this? But in major question, you should ask yourself, what is making me do this? Is there some hidden motive, some hidden impulse? And a judge has the duty, the sworn duty, to ask himself or to ask herself this question in every case. If you had a case where you decided a case between A and B 3 months ago, and you said the law is this, the rule is this, then 3 months later you have X and Y, different parties, but the same issue. Do you say, oh, I've just resolved this before? Well, you should be consistent. The law has something called stare decisis, which means that you should give great weight to the precedents that decided before, including your own. And you can't just be willy-nilly say one thing one day and then one day the next, or then the law gives no instruction. Mm-hmm. So of course you give weight to what you've done before. On the other hand, you have a sworn duty to the parties, X and Y, the second people to come before you, to ask, why did I do this before? Who am I? What is it that is making me, that is about to make me make this decision? And that's the fascinating part about being a judge or a justice. You must always ask, who am I?
In that, especially in that context, what is your assessment or perspective on textualist and originalist approaches to legal interpretation?
There's a big argument, the law students here know it well. Do you interpret the Constitution based on so-called originalism, i.e. what did the framers mean at that time? Or do the words like liberty have a spacious concept where we learn more about it over time? The originalist, Justice Antonin Scalia was one of its principal proponents, was you look to what the framers thought it meant, and that's it. But in my view, the framers were modest enough that they did not think that they knew all of the aspects of a just and decent society. And if they'd have known it, they would have written it out. They use words like liberty because it has a spaciousness, and you learn more about what it means over time. And that's the difference between originalism, sometimes called textualism, and pragmatism, what is the best result. Now, you have to be careful. The merit, the strong point about originalism is that judges don't resolve every social issue, David, that comes before our society in any given time. Lawyers are now skillful about putting almost any interesting social question into the context of a case. What is it that's cautions the court about not deciding every social issue? So you have 9 justices doing what really legislatures and states should do. So there's that conflict. But it does seem to me that liberty is understood over time.
Well, I want to talk about liberty in a moment because it's such a central theme in your book. As you just noted, some judges embrace the term originalist, others obviously don't. And maybe this is a huge oversimplification, but did you ever have a label that you put on your own judicial philosophy, or did that not apply to you? Or how would you describe your own judicial philosophy?
That it was right.
Okay. There you go.
No. It seems to me that my philosophy and that of many other judges is to look at all components of judicial interpretation. Originalism is of tremendous importance. What did the framers think? They didn't sit around reading dictionaries all day long. They used words that would have a meaning over time. But originalism is part of it. And ultimately, what is moral, what is just, what is right are of tremendous importance. And you have to understand that your opinion should have a context in which it commands or inspires allegiance to what you've done. One of my difficult cases was the flag burning case. Texas had a law which made it illegal to burn the American flag. And some young man, I forget what he was mad at something. He burnt an American flag. The state of Texas prosecuted him, and actually he was sentenced to some prison time for burning an American flag. And the case came to us. And it was very interesting, David, the difference on the court. 3 of the justices who thought that you must protect the flag and that the Texas law was correct had fought in World War II. Stevens, Rehnquist, and White. They had fought in World War II. To them, the burning of the flag was something that we must protect because we all honor the flag. On the other hand, this is speech. People initially say burning something is speech. Well, it's expression. We express our views in many different ways. And this was prohibited because of the message, and the state did not approve of the message. And the ruling was 5-4, in the opinion that I wrote. I said it's poignant but fundamental that the flag protects those who hold it in contempt. And my teaching was in Austria. I taught in Austria for many years in the summertime, and the opinion was announced just a couple days before we left. 80 senators got to the floor of the United States Senate and denounced the opinion. Newspaper editorials were very strongly, in most cases, against it. But then, and this was coming over to me, we looked at the news when we were in Austria. But then we noticed that more and more people were having second thoughts. People said, that's my speech right. It may be that I say something or do something under the First Amendment to express a view that people don't like. And gradually it changed. And that's why we write opinions. We give reasons for what we do. And we hope that those reasons lead people to respect the court even if they disagree with what we did. And this happened very much in the flag burning case. Over time, it became clear to many people that the court had reached the correct decision.
And in that specific case, if I remember correctly, Justice Scalia joined you in that opinion, correct?
Yes, Scalia joined.
And I think one of the layers of or elements of your point is that how the different justices decided wasn't necessarily intuitive, right? Some would have thought Scalia might have said it's illegal to burn the flag. But in fact, he joined.
Well, and of course, part of the question was, well, if you have what about the Texas flag, the Lone Star State? What about the the California flag, the Bear Flag Republic? Can we protect those? Well, then you've got 50 plus 1, now you've got 51 different rules. And this is a great lesson in free speech. Once you start out suppressing freedom of speech, freedom of thought, there's no ending point. Of course, there's some speech that's unlawful. Defamation, criminal conspiracy, but the mere expression of views is not right. After we had the flag burning case, there were some protesters in front with signs going up and down, protesting the court. But then there was a group of students who'd come to see the court. They probably maybe 8th graders, and they all stood together and they saluted the American flag, and the protesters looked at that and they became more quiet.
So let's go to page 217 of your book. You write, I found myself in the position of being the 5th vote in many of the court's most widely discussed decisions and being assigned to write a number of those opinions. While I did not pay much attention to the media reports about our work, it would be disingenuous to deny being called the swing justice by the press. That term always bothered me. The case is swung, not me. Can you elaborate on that?
Well, the term swing vote gives you an immediate picture of this judge going back and forth on a rope, left to right, left to right. That seemed to me quite wrong. It seemed to me that my philosophy was quite consistent, and the cases were just different, and it was the cases that were swinging, not me.
Your Catholic faith comes through very, very powerfully in the book. You also talk about abortion and rulings on abortion. Can you tell us about your grappling with that set of issues, and you even at one point thought you might want to step down from the court? Can you tell us more about that?
Well, in the abortion cases, my own belief, the book indicates that my best recollection is that I never heard the word abortion until maybe I was late in high school or in college. We didn't know what it was. My father must have known because he practiced law. And my mother knew because she was instrumental in having a facility to house and to nourish unwed mothers so that the baby could be brought to full term. Mothers who had not been married but who had gotten pregnant. And so my parents were very, very much motivated by their Catholic faith, as was we, as were my sister and brother and myself. And it seemed to me very, very wrong. There is a voice crying out from the womb, from the moment of conception, let me live, let me live. And that's a voice that seemed to me we had to hear, and this was my Catholic faith. Could I decide a case that was contrary to my Catholic faith? There was a very strong argument that in the early term, and this was only early term, pre-viability, that the woman did have the right to choose. And in my view, we should do everything we can to persuade the woman not to have the abortion, but that she had the right to make that call. And some women, unwed mothers, poor, maybe they were already raising other children and the husband was never around. So they had what they thought were good reasons. My answer was we should persuade her in the exercise of our faith and good judgment not to have the abortion, but that was her right. Was it proper for me as a Catholic to sit and make that decision that it was her right? And my thought was maybe I should leave the court. But as a practical matter, there would have been a big debate over it, and then the result would have been to appoint somebody who was more in favor of abortion. So as a practical matter, it didn't make sense. And as a philosophic matter, it seems to me that even though you have a strong religious faith, that doesn't mean that you shouldn't sit on the court and recognize that other people have a right that supersedes it. But it was a difficult case.
As a side note, while there have only been 2 Catholic presidents, I think we have a majority of members of the court are actually in fact Catholic, are they not?
I think 4. One more, we can rule the world. Well, I'll have to think. Well, there are a number,
Yeah.
yes.
Great. You write in the book that Brown versus Board of Education was right when it was decided, and Plessy versus Ferguson was wrong on the day it was decided. Can you tell us a little bit about that and how you came to that conclusion?
Plessy versus Ferguson was in the 1890s, and it involved what became to be known as separate but equal. And the court said it was lawful to separate races if they each had equal accommodations, and this was a railroad train. and if the railroad car, or the passenger car, was similar in its comfort, you could put black in one car and white in the other, and this was called separate but equal, because the accommodations were equal. The court in the railroad case cited public schools, because at that time all southern states and many other states and some other states had segregated schools, and the court said, well, of course we can have segregated schools. So this railroad case became very important as a precedent for segregated schools. The NAACP in particular, but other attorneys as well, wanted to attack Plessy Ferguson in the 30s, and they recognized that if they immediately attacked education in all public schools, there would be a tremendous public outcry. So they had what they called the beachhead strategy. They decided that they would have only the clearest cases of the wrong and the injury that discrimination based on race causes. And so they had a case called Sweat versus Painter, in which Texas had separate law schools for black and white. There was only one black student in the separate school. And so he had no one to talk to. As if you have some law students here, know that one of the biggest parts of law school was classroom discussion and study group discussion. Yeah. He had no ability to do that. So cases like this were the ones in which they began to establish that segregation was wrong, and the so-called beachhead strategy. And then finally, Brown versus Board of Education came, and Thurgood Marshall was the attorney for the NAACP, and he argued in the case. And Brown versus Board of Education was one of Earl Warren's first cases. And Warren worked very hard to have a single, unanimous opinion saying that separate but equal was unlawful and schools could not be segregated. He wrote an opinion. You write opinions, David, as you know. If you have an opinion, the flag burning case is a result of Brown versus Board of Education, another one, that's going to be read by a great many members of the public, then you write it differently than if you have, say, a securities law case or a corporate income tax case. You write it differently. And Brown versus Board of Education is something you can read. It's well written. And I'll make it up, maybe 18, 19 pages. And Earl Warren wrote it in order to convince the people that it was right. And Thurgood argued the case. Thurgood Marshall came, he was an icon, and he came to the Stanford University campus to visit, gave a talk at the undergraduate political science group, and then I think went on to the law school. And they asked me and one other to be his greeter and to take him around the campus. And he was an icon at the time, a great trial lawyer. And I introduced myself, gave him his name, and I think he remembered my name for 40 minutes. And when I saw him years later and became his colleague, he forgot all about it. But it was a great moment for me. Thurgood liked me very much because we were both trial lawyers, but he tried cases where a capital sentence, a death penalty, was on the table. He'd had to go into the town in one car in the south and then leave in another car. I had small cases. I didn't have cases like that. So when people say, "Oh, you're both trial lawyers," there was something quite inaccurate about that. He tried many cases of grave import, and my criminal practice was smaller and driving under the influence charges and things like that, not criminal, not capital punishment cases. But we became very close. And Thurgood had a wonderful sense of what was right, and taught me a great deal.
We hear so much about division on the court. Obviously, there were many 5-4 rulings, but what was it like? And maybe your discussion just now of your relationship with Thurgood Marshall is a good indication of what's the collegiality, or what's the dynamic across the ideological spectrum on the court. What are some of those dynamics that the public should be aware of?
Well, just one more thing about Thurgood. It seemed to some of us important for Thurgood to write a memoir. And they asked me, my colleagues asked me to go in and plead with Thurgood at least to do an oral thing where we could hook up a tape recorder and have him talk about it. And he agreed to do it, but then 3 days later changed his mind, so we never did have it. The dynamics on the court, we, as indicated in the book and just maybe mentioned earlier, we had 9 of us together for 11 years in the same room at the same table. And Breyer was the junior justice for 11 years. The junior justice is in charge of the cafeteria. When we got a new justice after 11 years, Justice Alito came. Scalia and I made the motion that the second junior justice should be in charge of the cafeteria. So we were 9 of us together for 11 years, and it was a wonderful dynamic. With Scalia and me, he knew that I knew that he knew that I knew what he was going to say next, so we could kind of start from there. And we had wonderful discussions and great collegiality. My concern about our present day is that I hope the lack of civility which we see in our society generally does not come to the court. Some of the opinions, David, if you've read them, are ones in which the majority and the dissent attack or criticize other judges as judges, not just the result. There's some personality creeping into it. And one of the things that Ronald Reagan said was that freedom lasts one generation, the next generation, and you have to work to keep it. And we have to work to keep our freedom by ensuring that we have a civil discourse. Freedom, democracy, presumes a rational, thoughtful, careful, respectful discussion where we disagree, and you have strong views, or I have opposite strong views, and we go out to lunch together afterwards. Aristotle said that democracies can die, and he'd seen it happen. And democracies die when there is a lack of civil, respectful, thoughtful discourse. And this is, as is indicated just a few minutes ago, something that Reagan would have been very, very concerned with. He was wonderful about saying that he disagreed with you, but thanking you for your views. One time, I told him, now the legislature is considering this, and the beginning point is X. And he said, well, I'll veto that. I said, no, Governor, I said, I'm sorry, that's already the law. But maybe you can get around it some other way. But Reagan was very interested in the appointment of judges, and I explained to him how important trial judges were. Bill Clark was basically a rancher. He had a law school degree. Clark passed the bar after only 2 years of law school. He didn't even have a third year of law school. But he was a confidant of Reagan, and Reagan believed him because he always said exactly what he thought, and it was always on. Reagan was absolutely honest. We usually think of honest politicians as not taking money and so forth, and of course that he was very honest in that respect. But he was also honest in the second way, and he was honest in the views he expressed and the views he held. That is something that we must have in our democracy. But he liked to appoint trial judges, and he liked to hear me talk about what the English bench was like and how proud the barristers were to be members of the bar and how good their judiciary was. Mary and I, David, when we go to London, the best show in London is at the Old Bailey. Forget the West End $100 ticket to see the theater. Go to the Old Bailey and see a trial. It is simply wonderful. The last time we were there, the barrister said, "And now, my lords, I wish to turn to the statute." And in statute, we have what we call maxims of statutory construction, rules for construction, but they cancel each other out. Like stitch and time saves 9 and haste makes waste. You know, you can say the same thing. And so the letter, if counsel begins to quote the maxims of statutory construction, I shall be forced to leave the room. and the barrister said, "Oh, my lord, I would not wish to precipitate such a calamitous event." And Reagan loved those stories. One judge said, "Counsel, you've gone on for some time, and I'm no wiser than I was before." And the barrister said, "Sadly, no wiser, my lord, but perhaps better informed." and Reagan loved stories like that.
I think we're really onto something.
And he was very careful about the judges. He knew that the appointment of judges was one of the most important things that he could do. And as indicated, I told him that he could never ask me who should be appointed a judge. But he was very, very careful about that.
On the topic of civility that you just addressed, it's precisely with many of the issues that you just stated that we as an organization, the Reagan Foundation and Institute, launched our Center on Civility and Democracy to find ways where people of principle, people who may feel strongly, can still disagree with each other and find common ground. So if anybody is interested in that, go to reaganfoundation.org and our Center on Civility and Democracy. We are 25 years from Bush versus Gore, and are there any insights or reflections you care to share on that momentous decision?
Bush versus Gore came to the Supreme Court of the United States. Whether or not the Florida ballot count was something that there was a constitutional violation in the way it was handled. And people have to remember that the case was originally called Gore versus Bush. Gore brought that proceeding. Everybody said, "Oh, Bush went to the courts to get..." Gore brought the case. And the argument was that it was wrong for Florida to count just, I'll make it up, 7 electoral districts and not all of them. If you're going to count, you have a recount. You don't just select the districts in which you lost. 7 justices on the Supreme Court agreed that we should take the case. And 6 judges, at least, maybe 7 as well, agreed that there was a constitutional violation. Oh, and the case gets changed. When you come to the Supreme Court, the party that didn't prevail below is the first name. So Gore versus Bush changed it to Bush versus Gore, but Gore bought the case, and which even commentators sometimes forget. They think, oh, Bush bought the case to become president. And 7 justices, perhaps, but certainly 6, agreed that there was a constitutional violation. And the only question was the remedy. And Gore had urged and prevailed in the lower court on extending the first part of the counting process, and he wanted to extend it further. The majority of the court said that you were the one that caused the shortening of the period. You can't now argue about it. And so that was the decision. And there are studies which perhaps show, I think they do show that Bush did win anyway, if you did the counting, although there may not be 100% agreement on that. But it seems to me that after the fact studies 4, 5, 6 months later show that he did have the votes. But it's clear there was a constitutional violation. What's the court supposed to do? Say, oh, there's a constitutional violation. There's the president of the United States being decided. It's a state court. We won't take it. Well, that's ridiculous.
There are many students in the audience, both in person and online, and it may be a short answer, but what is your advice to aspiring law clerks?
One of the things we look for is judgment, and we hope that law school, like many other schools, many other disciplines, teaches you to use good judgment. And it's fascinating that in law school our inventory, as you know well, David, consists of disputes. All of those books on the wall, I don't know if they have them anymore with the cyber age, or all those books you see on the walls of an attorney's office or a judge's chambers are what Holmes called the story of our moral life. It goes back hundreds of years in which we see the evil acts of some people, the honorable, inspiring acts of others. It's the story of our moral life. This is our inventory. Our inventory is one of disputes. And in the context of learning how to settle disputes, of course, once again, you begin with insisting on civil discourse in which you meet with your co-students or your colleagues, and you discuss in a professional way what the law ought to be, and it's fascinating. And again, you learn about yourself.
I was surprised to read, switching gears.
And incident, in law school we have study groups. As 3 or 4 students get together and they discuss the cases that have just been taught or that are going to be taught the next day. And this is a wonderful dynamic in law school. You meet your fellow students who will soon be your colleagues in the profession, and it's what keeps our profession strong and aware of social changes.
Switching gears again, you've been to China several times. You've even met President Xi Jinping. So I wonder what your reflections are on meeting President Xi, and how have your views evolved over time, if at all, with respect to China?
I went to China probably 20 times to teach for just a week or 2 weeks. And in the 80s, when I first got there, I was appalled at the curriculum in the Chinese law school. In most countries of the world, law is an undergraduate degree. There are no professional law schools 3 years as we know them. Only 5 or 6 countries have three-year law school. In China, law is undergraduate. And I looked at the curriculum, and it broke it. It made no sense. Most of it was memory. It would be as if in the United States, law students had to know how many judges are in the Supreme Court of all 50 states. I mean, who cares? They had questions like that. These attorneys, based on their law school training, were just not qualified to practice law and to meet, as China had to do now, with attorneys and go to courts involving other countries. And so my initial project was to convince law school deans that they had to change their curriculum. And I met with the students of Renmin or the deans and presidents of Renmin and Beida universities, and they agree with me. And so they called together the deans from 15 different law schools, and they said, "Now you stay here for 2 weeks, and we'll." I said, "No, I've got to get back." But they did change the curriculum, and it's much better. And one of the things, and I'm very proud, and they established a law school, and I went down to give the inaugural speech for opening the law school with this new curriculum, and it's in Shenzhen, which is in southern China. And the University of Beijing already had their medical school and then an engineering school there, and a beautiful piece of property, and that's where the law school is. So we were very proud of the law school, and one of the students, one time when I was speaking at one of the law schools, said, "I'm Justice Kennedy here to tell you about the rule of law." And some student raised his or her hand. There were probably 800 students in the room, and said, "What does the rule of law mean?" Well, I'd never really thought about it. And I usually explain questions in terms of 4 parts, but 4 is an unlucky number in China. And 3 is a lucky number, so I said it has 3 parts. And I said the first is that the law binds government officials. The second, the law protects human dignity. And the third is the law is accessible. And the UN wrote it up. These are rule of law bookmarks, and I sent for some for everyone in the room. I don't know if they've been, but you'll get them.
We will figure it out.
Give you 500. And the UN has translated it into 15 different languages.
The one you gave me has Portuguese on the back.
These are rule of law bookmarks.
And it's Portuguese on the back of the one you gave me.
Yes, that's Portuguese there.
Great. So the rule of law bookmark. Check it out.
I asked for some for the audience, and I don't know if they ever got here or not, but we'll send you 500 and you can give them.
A fun fact, the Reagan Library has been sanctioned by the Chinese Foreign Ministry because we hosted Speaker McCarthy and President
well, you asked me
Tsai
about President Xi. I met with President Xi. I met with 3 Chinese presidents, and when you meet with the head of state, there's always more in it for them than for you, so you're wondering if you're being used somehow. But the State Department urged me to accept the invitation. President Xi is a very learned person. He reads Shakespeare. He can tell you he likes to discuss. We talked about Macbeth. He said, you know, China and America are different. In China, we begin with consensus and then we debate. You begin with debate in order to find consensus. And you don't usually argue with heads of state, but I said, with all due respect, Mr. President, we too begin with consensus. We respect the dignity of every person. And we then begin from there. And the State Department, man, it was there, he liked that. But when Hong Kong became part of the mainland and its legal system was terminated, many of us, or some of us, including some real experts in China, I'm kind of a gadfly, thought that this would bring the idea of the rule of law to the mainland. And Confucianism, which is thousands of years old, is, we thought, still part of the Chinese mindset. But I forgot to reread George Orwell's 1984 and Huxley's Brave New World. I forgot how oppressive and efficient a dictatorial government can be. And in China, they have been rather successful in expunging any idea of judicial independence or the rule of law. It's very distressing to me. Again, my hope is that new generations of young people always want to make change. And is there some hope that the new generation will want to make change and go back to the values of Confucianism and of the pre-communist times? I'm not so sure.
You conclude Life, Law, and Liberty with this thought on page 296. A judge must always continue to learn. It is my hope to do so, always to see what might be just beyond. So if you would leave us, please, with a final thought on striving for something greater than ourselves, as you suggest.
Well, again, we must insist that this idea of partisanship become less important. Every president has appointed judges usually of the same party. Eisenhower didn't. He appointed Brennan. And he appointed Warren, who was arguably third party in those times. But partisanship should be just a factor, not the dominant factor, because we must insist, number one, that we have, instead of party identity. David, when the cyber age came, I thought, well, this will be tremendous because more people will talk to each other. But what happens is people get on the cybernet and they want to talk to only people of their same party identity. And they assume that if you're a party X, you believe all of this. If you're party Y, you believe all of this. And this is most unfortunate. So it's worked actually, the internet's actually working the other way around. And again, we must restore civility. We must do that now. We must have a better public dialogue. We must do that now. The idea, we must be against vulgarism in our society. It was amazing to me that members of Congress would go on the television and use four-letter filthy words attacking other people.
That's getting worse now.
Maybe it is free speech. But free speech doesn't mean that you should use vulgar language and epithets. The rest of the world is watching America to see what free speech means. Is the rest of the world impressed by our public dialogue? If it's not, we have to change it. We have to change it now. We have to change this party identity, party identification. Now. We have to change the lack of civility now so that freedom exists for generations still to come.
I think that's a perfect note on which to conclude. Let's thank Justice Kennedy for life, law, and liberty.
Thank you.